while you're waiting. Please have a seat.
Yes, thank you.
Before that, can you please brief me my schedule for today?
Today you will have 3 meetings. First one at 11 p.m. with the CEO from Dato Amir company, and 2 meetings in the evening.
Okay, so I think I'm quite busy today, so can you please make it quick and we can start now.
Okay, so good morning, Dato' Salwa Pinky. Thank you for calling us in today. My name is NURUL. I'm the corporate lawyer with AI Advocates, and here is my fellow corporate lawyer, IMAN EZANI. We very appreciate the opportunity to meet you today and discuss your legal needs. So, first of all, during this initial consultation, we will first learn about your business and your specific issue that you are facing now. And we hope that by understanding your goals and challenge and concern, we will be able to provide you with tailored legal advice guidance. So, before we proceed, my apologies. Before we proceed further, I would like to discuss on the topic of consultation fee. So that we have the mutual understanding, and also at AI Advocates, we believe in providing high quality legal services tailored to your specific needs. As such, we do charge a consultation fee for our times and expertise, together with my fellow lawyer. So Datin, our consultation fee is based on an hourly rate which cover our time reviewing your case, researching for any applicable law and regulation, and providing you with comprehensive legal advice. So our hourly fees start at 1,200 ringgit. However, Datin need to know that this fee is only applies to the initial consultation, and for any other additional services or representation will be discussed separately. It also depends on time we spend for consultation, and the final fee also may be vary. Iman, can you pass me the document? So Datin, here is the fee. As you can see the details here. So please let me know if you have any question or if there is anything else you would like to discuss regarding our consultation fees.
So shall we start now, Datin? Okay. So first, you can start by telling us the background of your company and the issue and concern you are facing. We will try our best to provide legal advice to your issue.
Flashback.
Yeah, I think that's a good idea. I'm so excited. Oh, of course, I'm going to the cafe thing. Okay. Do you want to take a look? Okay, come on. Come on. See you, Debbie. Okay, where is he?
Secretary Office.
Hello?
Hi, Datin.
Yes?
Datin, I just received call from hospital that Datin Razi was involved in an accident.
Are you serious?
Yes, I am serious.
Where is she right now?
Hospital Sultanah Zahirah in the ICU.
Oh my god, I'm on my way!
Okay, see you there.
End of flashback.
Alright, Datin, based on the story you just told us, we think that the right way to wind up your company is by members voluntarily winding up. Usually this procedure is affected by resolution as we take into account, we confirm that the company is solvent.
Could you please enlighten me on the process of liquidating a company? As a director, I'm aware that this can be a challenging task.
Yes, sure, Datin. We will explain to you the procedure step by step. So basically, once the decision to wind up the company is made, the next step is to draft the special resolution. In the resolution, the intention to wind up the company must be clearly stated together with necessary supporting documents such as financial statement of the company and also the statement of affairs. Then, Datin, solvency test and solvency statement is needed. I will now explain what is solvency test and solvency statement to you. So basically, solvency test is an evaluation to check if a company or a person had enough asset to meet their financial obligation. It's all about determining if they can pay off the debt and other liability on time. And also, next, the solvency statement is a formal declaration made by the company's director or executive, which is you and your board of director, and it's confirmed that they conducted a solvency test and believe that the company is financially sound.
Alright, Datin, so after all the procedures has been made, then we will move to the appointment of interim liquidator, where the company will need to appoint an interim liquidator and notice of appointment, and a copy of the declaration lodged with the registrar shall be advertised in the newspaper. It must be both national language and in English. And then the voluntary winding up should commence where interim liquidator has been appointed before the passing of special resolution, where in this case the directors need to declare that the company is financially sound before certain corporation actions. So in this case, Datin and the company must do so within a set time frame and back it up with some documentations which we will be explaining further. And the false declaration shall also have legal repercussions.
I would like to understand the impact of winding up a company. Will this restrict my ability to engage with other business activities?
Yes, that is Salbia. When your company voluntarily winding up, the company need to stop its normal business activity, which is the car rental. However, the liquidator can still proceed with certain businesses activity which it thinks necessary and beneficial for winding up the company in the best way possible. But I think in the legal existence and authority of the company as a corporate entity will continue until the company is officially dissolved. As long as the company did not dissolve, it remains as corporate entity unless otherwise stated in your company constitution. And I also need to remind you, Datin, that any transfer of share or changes in membership status made without liquidator's approval after the winding up process begin will be considered invalid.
Okay, I get it now. But then who will carry the responsibility of distributing and managing the company's assets during my winding up process? Because I suppose it would be different than in normal situation, right?
Alright, Datin Salbia. So usually the company must appoint one or more liquidators at a general meeting in which this particular person will settle all the company's outstanding liabilities. Basically, the liquidator will take charge of your company in this affair and work towards distributing the remaining balance to the members after settling these debts. So what I'm saying is that the appointment of liquidator ensures an orderly settlement of the company's debts and liabilities. They are responsible for handling the winding up process, assessing the company's financial position and paying off creditors, as well as distributing any remaining assets to the members.
So once this liquidator is appointed, so what will happen to us? Does this mean that we will have no involvement in the winding up process?
That's a crucial point, Datin. Upon the appointment of the liquidator, the power you and Datin Rozi have as the director will cease. This means that you both no longer have authority over the company's affair. The liquidator assumes control and makes decisions regarding the winding up process. Also, the director's involvement in the winding up process become limited once the liquidator is appointed. However, it is important to note that the director still has obligations to cooperate with the liquidator, such as provide necessary information and assist in smooth transition. And also, Datin, we would like to remind you that during the winding up process, any document or communication issued by the company should be clearly marked with the phrase in liquidation. By incorporating this phrase into document, it helps to provide transparency and clarity, also ensuring that parties interacting with the company are aware of its winding up status.
Also, Datin, I would like to add that the creditors are prevented from enforcing any orders after the process of winding up has been initiated. This basically means that once the winding up process begins, the creditors are legally restricted from taking any actions to enforce their claims against your company. Not only that, the publication of the winding up notice serves as a notice of termination, which is when your company publishes the winding up notice, it effectively informs the public, including the creditors, stakeholders, and other interested parties that your company is indeed undergoing an winding up process. I think that will be it. Datin, from me, do you have anything?
I think that's all for me. There's nothing to add.
Alright, okay. So Datin, we understand your concerns, but basically don't worry too much. The important thing is to stick to the law and follow the necessary procedures. If you do that, you will be able to handle the winding up process smoothly.
So I totally get all the advice you gave, and I really want to thank you for the awesome consultation. Your explanation were very comprehensive, and I feel like I've got a solid grasp on this matter. Big props for taking the time to advise all my concerns.
No problem, Datin. We are glad to hear that we could shed light on things for you. It is our job to break down the legalese and make it accessible. We're always here to provide comprehensive advice and help you navigate the legal landscape.
I sincerely appreciate your dedication and expertise. Your service have been invaluable. Thank you once again for your time and assistance.
You are most welcome, Datin. It's our privilege to serve you. We wish you the best in your endeavors and are here to support you whenever you require our assistance. And also thank you for choosing our firm.
3 days later.
From the story of Latin Salvia, I believe members voluntarily winding up is the best way to wind up the company. However, it all depends on the company's solvency test that will be done by them. After the company is solvent, they need to make the declaration of solvency to declare that the company will be able to pay its debt within a period not exceeding 12 months after the commencement of the winding up.
Yes, true. However, if the company failed to prove that they are solvent and in fact is insolvent, they should convert to creditors' voluntary winding up, which is to be initiated by the members in the beginning. The insolvency of the company needs to be declared at the board of directors meeting. Then, 2 meetings are required to be held, which is the members meeting between the members of the company and the creditors meeting involving all creditors of the company.
Yes, true. The company must hold a meeting of the creditors immediately after the members' meeting, and they must appoint a liquidator in which the person appointed by the creditor will prevail over those appointed by the company. And the said liquidator will then determine whether the appointment of a committee of inspection is required to oversee and make sure everything is done properly during the winding up process.
Yeah, correct. After that, the winding up shall commence at the passing of the resolution of the voluntary winding up.
Yup, I guess that will be it, right? I think I have to take this call. We can end it here, right?
Yes, sure. I'll see you tomorrow then.
Okay, bye.